Welcome all. My name is Dr. B.S. Patil. I am from V.M. Sargaonkar College of Law, Goa. Today I am going to discuss on module 15 of access to justice topic. Under this module 15, we are going to take up a discussion on access to justice of laborers. Basically, the topic given to me is access to justice and labor law. Now, here basically we are going to discuss and try to understand how far the workers have an access to justice and how far the laws have been framed to provide access to justice for these struggling, fighting workers. And if you take up my presentation, I have framed a scheme of my presentation. And basically under this scheme of my presentation, I am going to ascertain the provisions of Industrial Disputes Act. Under this Industrial Disputes Act, I have classified the dispute resolution systems proposed by the Act into different categories, namely inquisitorial method, where one authority under ID Act would be taking up inquisitorial style of resolution of dispute. There is cooperative method, where there are two authorities dealing with this cooperative method. There is preventive mechanisms, where there are quite a few, 2 or 3 authorities who deal with preventive processes, and then finally we are coming up with the adversarial mechanism for resolution of dispute. Now, when we discuss these disputes resolution mechanisms, we should not miss out, or we should not forget the object of the study. The object behind studying this is basically to understand the need and the meaning of labor jurisprudence. Basically, do we need a different style of jurisprudence for laborers, workers and industries? Trying to analyze, understand the concept of industrial dispute, as this is not an ordinary dispute, this is a dispute concerning an industry. When a dispute is related to an industry, what is its impact that it can create on the society at large, parties specifically, and various other stakeholders. And also we need to try to identify and recognize various methods of resolution of disputes envisaged under this legislation. To begin with, labor jurisprudence has an ancient origin. It came into existence way back in 1850s. There are two major legislations which came up during that time, that is the Fatal Accidents Act and the Employers Liability Act, which actually resulted in advent of jurisprudence on laborers or workers. The reason behind passing of these legislation is unholy trinity of 3 defenses which was existing during that time, that is doctrine of common employment, doctrine of added peril and contributory negligence. So, these 3 defenses were available to employer, and he used the employer used these defenses for his own benefit, resulting into exploitation of workers. To restrict the employer's ability to use these defenses, they passed these 2 legislations. But today's discussion is not related to workers' rights. Our discussion is related to workers' right to access justice. So, keeping that in mind, if you look into the evolution of labor laws as to access to court, access to justice, it has a very recent origin. It came into existence only in the year 1929, and that too they came up with only 2 authorities to deal with these industrial disputes. And then came up the present legislation, that is Industrial Disputes Act 1947. Which is still in operation, and it has been subjected to various amendments. So, now why do we need a separate legislation to resolve a dispute? why can't ordinary civil court take up the labor disputes? Why we need these separate remedies? The reason being, there is multiple reasons for this specific legislation. Now, I am going to take up one basic reason for this. The industrial relations, having an effective industrial relations leads to industrial peace. Industrial peace leads to better and higher production. Better and higher production leads to stronger national economy. So, therefore, prevention of dispute or at least early resolution of dispute is in the state's interest, not only in the interest of the parties. So, therefore, there is a separate legislation to look into the industrial disputes, because the impact of industrial dispute is much larger than individual disputes among the private persons. So, that is the reason why we have a separate legislation to deal with these disputes. Now, let us look into the importance of early resolution of disputes. Now, if a dispute is avoided, nothing like that, that is the best thing that can happen to an industry. But if this could not be avoided, then it must be resolved at the earliest. Why do we need to resolve it at the earliest? The reason being, the absence of dispute leads to continuous working of industry, which leads to continuous production and which strengthens the market and the economy of the state. Secondly, when this continuous production is going on, there is a continuous work for the workers, which helps in horizontal distribution of strengthened economy. The benefits of the strengthened economy would be horizontally distributed rather than vertical distribution. And lastly, and the best reason is, it helps us to make an optimum use of the resources available. So, therefore, in other words, amicable prevention or settlement of dispute. Here I prefer to use settlement, because settlement of a dispute has got a wider and larger impact on the relation than the resolution of a dispute. So, amicable prevention leads to reduction in disputes, reduction in disputes leads to improved cordial relationship, and very importantly, this improved cordial relationship discourages unfair practices, and absence of unfair practices leads to further amicable relationship. Further, speaking about why we need a separate process, cordial relation gives higher moral gives high energy and dedication, and in turn it provides higher production. Now, these are from the point of view of workers. From the point of view of employer, the last one, employer would not hesitate to invest in social welfare measures for the benefit of the workers. So, why these things are happening? These are because of avoidance of disputes. Coming to the remedies provided under the Industrial Disputes Act. So, ID Act has developed multi-pronged approach. Multi-pronged in the sense, there is a series of attempts made to resolve dispute. First, there is an attempt to have an amicable settlement of a dispute. Next, there is an attempt to adjudication. Then there is an attempt for state intervention. Let me put up in a graphical format of Industrial Disputes Act resolution systems. As I said, there are 4 styles of resolution of dispute adopted by ID Act. Number 1, preventive methods. Here we have works committee to do that job. Inquisitorial methods. Court of inquiry is an authority which does a work which may not be identical to inquisitorial style of functioning, but mostly it resembles inquisitorial method. Cooperative method. Conciliation officer and board of conciliation deal with these cooperative methods, including grievance redressal mechanism. And lastly, adversarial method, There were labor court, industrial tribunal and national tribunal deal with such processes. So, these are the authorities involved with the resolution of dispute. Before going into the powers, functions, duties of these authorities, let us look into another important player in this whole industrial scheme of Industrial Disputes Act, and the player is appropriate government. Section 2A defines appropriate government. So, either it can be a central government or the state government, which can be an appropriate government. Now, what this appropriate government does is it has withheld or it is holding the right to refer the dispute to different authorities, and this right is exercised by the appropriate government depending upon the urgency of the matter. So, what powers does this appropriate government enjoys? It has got 4 important powers. Number 1, appropriate government can decide whether to refer or not. So, therefore, parties have no direct right to approach these authorities. It has to be through a system called a referral system, and here the appropriate government can decide whether to refer or not. Secondly, when to refer, the time will be fixed by the appropriate government. Thirdly, whom to refer, whether it is conciliation or board of conciliation, whether it is court of inquiry, whether it is other authorities. And lastly, and very important, after referral of a dispute, the appropriate government continues to enjoy control over the dispute, and here they can withdraw the referral, they can re-refer to somebody else, they can amend the award pronounced by the authority. So, therefore, the appropriate government, graphically speaking, appropriate government can refer 2 kinds of things to the authorities: the dispute between the parties as well as connected matters between the parties. Now, below I have given the list of authorities to whom such referral could be made. Coming to the first method, that is inquisitorial method. Briefly speaking about inquisitorial method, here is an authority who does everything from receiving complaint, investigating into the complaint, arguing the complaint and pronouncing the judgment on the complaint. So, this is the fastest way of resolution of dispute. But what we have here is one authority who comes closest to this style of functioning, that is court of inquiry. Now, interesting thing about court of inquiry is no dispute can be referred to court of inquiry. What can be referred to court of inquiry is only the connected matters. So, therefore, court of inquiry it does not resolve any dispute, but it only look into the connected matters. So, let me explain this system with an illustration. So, let us see that there is a large scale retrenchment going on. Now, retrenchment means no work. So, you need not come to work, take some compensation and walk out. So, when there is a large scale of retrenchment going on, the dispute concerning retrenchment goes to various authorities, labor court, industrial tribunal, national tribunal, etc. But when the state, specifically the labor department, look into the issue why there is such a large scale retrenchment. Let us take example of that automobile industry. The automobile industry is undergoing this large scale retrenchment. Labor court, everybody is looking into the compensation part of the retrenchment. Court of inquiry would conduct an inquiry into connected matter. Why there is such a large scale retrenchment? Why do the automobile industries were unable to provide a job to these their own workers? So, they find out a reason that there is a slank in the sales of the automobiles, there is a dip, and the reason being the higher rate of interest by the banks as well as the higher duty imposed on the automobiles. Now, here court of inquiry found the reason for the retrenchment. So, immediately the labor department proposes changes into this tax system, as well as they make a recommendation to RBI to change the interest rate system. So, this is what the job of court of inquiry is. So, they do not deal with the actual dispute, they deal with the connected matters. Now, court of inquiry is headed by one person or two persons, where one person acts as a chairman, and they have a jurisdiction to look into all connected matters relating to the dispute. Now, coming to cooperative method. Now, this is a method where tripartite dialogue goes on between the parties. So, there is disputing parties, that is employer and the workman, and the next one would be the state, which acts as a facilitator, supplementer, as well as a person who is assisting the resolution of dispute. So, here predominantly we follow discussion or negotiation process, and the state, that is the third party, will try to ensure a win-win situation between the parties. Now, this system helps in maintenance and in the nourishment of the relationship between the parties. Once a party goes through the conciliation process, that is a cooperative process, they can expect better relationship between the parties with higher truth and faith amongst the parties. So, this is how the discussion goes on. The negotiation is between two parties, that is the employer and the workman. The conciliation officer acts as a facilitator. So, conciliation officer acting as a facilitator, is it mandatory or is it at the option of the conciliator? The answer lies in the classification of industry. So, if you look at industry, it is classified into two categories: importance. Based on the importance, we have got ordinary industries and industries called as public utility services. Depending on the size, we have three categories: large, medium and a small industry. So, large industry is the one with 100 or more workmen, and then between 50 to 100 is medium, and the small industry is below 50 workmen. Now, that is numbers are related to workforce. Now, here for today's discussion, we are concerned with the first classification, that is ordinary industry and the public utility services. So, where a dispute is concerned with public utility services, conduct of conciliation proceedings is mandatory, but whereas under ordinary industries, it depends upon the will and the wish of the conciliation officer, that too with certain guidelines. So, he enjoys a lot of powers as well as functions and duties, but he has been given only 14 clear days, working days, to discharge his duties. So, he cannot expect to keep on working out a kind of a settlement between the parties. He has to give result within 14 days. So, these are some of the important role of conciliation officers which he has to perform to be a successful conciliation officer. So, the role of conciliation officer when it comes to maintaining a relationship between the parties and settling the dispute between the parties, he has to play a multiple role, and some of the important role that he has to play is, he should first of all he should enjoy the trust and faith of both the parties. So, therefore, he should exhibit high moral standing among the parties. Secondly, after exhibiting his high moral standards, he has to make sure that he maintains a cordial relationship with the parties. So, when he is maintaining such cordial relationship with the parties, he can ensure cooperation rather than competition by the parties. Most importantly, he should also act like a friend and also a vent for an anger, because disputing parties have lost faith among each other, and as well as they have been maintaining a lot of anger within themselves, and there should be a vent to vent out the anger of the parties. So, he should act like a vent for the anger of the parties. and at the same time he should not allow the anger to be exhibited against the party, but he should take it on his own. So, when conciliation officer is functioning, he takes up two kinds of sittings. One is a private sitting, where the conciliation officer is sitting with the other party in absence of one party. So, here the discussion can be very much frank. They need not hide anything, as there is a only conciliation officer who is going to hear the discussion. So, at that stage he should encourage them to vent out their anger, not when the other party is present, because the moment they speak out emotionally, the discussion tend to get derailed and they tend to discuss emotional matters rather than the actual dispute in hand. Then the conciliation officer is under the duty to encourage the parties to adopt a cooperative method, and also he should also make the list of common interest between the parties as of conflicting interest between the parties. So, the interests between the parties are of two kinds, common and conflicting. Conflicting are the issues to be resolved. Then what is the use of making a list of common interest? Now, these common interests are the reasons for the parties to keep on discussing and negotiating. The parties are interested in resolving their conflicts, but at the same time they are much more interested in protecting their common interests. So, that is the reason why he need to make a list of conflicting as well as common interest. Similar to conciliation officer, there is a board of conciliation which is established by the state wherever necessary. Now, coming to the outcome of conciliation process. So, whenever a conciliation process is conducted, he is under the duty to report it to appropriate government. So, reporting is done under two different circumstances. Sometimes the conciliation officer succeeds in getting a settlement of a dispute. In that case, he has to send a memorandum of settlement along with the explanations. Sometimes conciliation officer or board of conciliation fail to come out with a settlement. Then they have to send an authority, it's a reference to other authorities. So, he has to report the failure along with the reference. So, these are the contents of the report. So, when it comes to failure report, the contents are as follows, that is, he has to ascertain the facts and circumstances relating to the dispute, steps taken to bring the settlement, full statement of facts and circumstances, and finally and very importantly the reasons in his opinion for the reasons for failure to come out with a settlement. And successful report contains memorandum of settlement along with the report of the conciliation officer. Another mechanism which tries to resolve a dispute is grievance redressal machinery. Now, this machinery it's an on-site machinery which functions in the industry, comprising of workers and the employer in equal number, and the chairman of this machinery is either employer representative or the workman representative on a rotational basis, and this try to resolve a dispute at the instance itself without wasting much time. This process was inserted into Industrial Disputes Act through 2010 amendment. The composition would be that equal in number as I mentioned, and one important thing which I want to mention is that the woman should form at least 50% of the representation. And when the grievance redressal mechanism comes into function, the dispute is referred to the committee, the decision of the committee is appealable, and from the committee the decision goes to employer in appeal and his decision becomes final. So, from cooperative method let us move on to preventive methods. Now, here preventive methods has got certain advantages, like it saves the cordial relationship. The moment you prevent a dispute, you are actually avoiding a relationship from spoiling. So, therefore, prevention is better than resolution of a dispute, and the authority which is being given an authority to prevent a dispute is works committee, and this works committee is supposed to promote measures for securing and preserving good relations between the parties, and it also has to make series of comments on the important matters concerning the workers and the employer. Now, these comments, even though they are not binding on the employer, but definitely it makes the employer to think about those situations. This duties of the works committee, the problem with the works committee is that the decision of the works committee is not binding on the employer. This is the major drawback. Second drawback is balance of power is in favor of employer, because works committee always has employer's representative as the chairman. And lastly, the trade unions do hardly cooperate with this works committee, as they feel that it is actually eating into their jobs, eating into their functions, making the presence of trade union redundant. That is the reason why they consider it as a competitor rather than an associate. Then coming to the last style of resolution of dispute, adversarial methods. Now, here in this adversarial method, there is a labor court, industrial tribunal, national tribunal, and finally arbitration. But anyway, the caveat that we need to have before going through this discussion is that adversarial method is the least preferred method when it comes to maintaining industrial relations. So, labor court deals with the disputes falling under the second schedule. It takes up disputes connected with standing orders, interpretation of standing orders, matters concerning the discharge and dismissal of a workman, and a district judge, a person who is qualified to be a district judge, could preside over the labor court. Industrial tribunal deals with the disputes falling under second and third schedule both, and it can take up mode of payment of compensation, it can take up wage fixation disputes, etc. So, this is how the qualification is being prescribed under the adversarial authorities. Labor court, the jurisdiction is schedule 2, and the authority should be district judge, qualified to be district judge or high court judge. Industrial tribunal, it takes up the disputes falling under second and third schedule, and it is going to deal with district judge, the qualification is going to be district judge or of a high court judge. National tribunal can deal with any kind of disputes, but only high court judge can be preside over it, and the dispute has to be of a national importance. If you look into the powers and functions of the adjudicatory authorities, they do enjoy series of powers and functions. They have a power, or in a way we can call it as a right to enter any premises for the purpose of conducting inquiry. They also enjoy the powers of civil court. So, other important powers are enforcing attendance of any witness, examination on oath, compelling for the production of documents, compelling for production of material objects, issuing commissions for examination of witness, all other powers of the court enjoyed during the judicial proceedings. Coming to the last authority, arbitration. Arbitration is an authority created by the parties themselves. So, broadly we can consider him as a private judge who is trying to resolve a dispute between the parties by pronouncing an award. He is a private judge because he is appointed by the parties themselves. Here the state has got no role to play, except it has got a right to be intimated. Other than that, it is completely the parties who control the proceedings of arbitration. There are few prerequisite requirements are there. Number 1, application. Number 2, written agreement, which is popularly called as arbitration agreement, and then the arbitration agreement must possess the name of the arbitrator. So, when you look into the outcome of these proceedings, there are two major outcomes of these proceedings, that is, one is award, the other one is settlement. Now, if you take award into consideration, the adversarial systems, that is labor court, industrial tribunal, national tribunal, arbitration, they end with award. So, therefore, it is a final or interim determination of an industrial dispute by any of these authorities. And once the award is pronounced, the award is produced before the appropriate government for its enforcement. The other outcome is settlement. The settlement is the outcome of cooperative methods like conciliation officer and board of conciliation. So, when this person takes the matter into consideration, the outcome would be a settlement arrived at by the parties. Please remember, it is arrived at by the parties with the assistance of the conciliator. So, this is what happens with the outcome of conciliation. And there are two kinds of settlements. Number 1, that is settlement during conciliation proceedings. The other one is settlement outside or other than conciliation proceedings. So, here we took up a basic discussion on what is the right to access to justice of our laborers, but during the discussion we have found that there is a speedy method process adopted by the legislatures whenever the dispute is concerned with the workman and the employer, but not to forget that there is a selfish interest in this, if I may permit it to say so, because protecting national economy, national interest being the paramount consideration, indirectly workers are getting the benefit of this speedy disposal of system. Thank you very much.